The marble halls of the United States Supreme Court echoed with the familiar murmur of the nation's legal elite. Reporters and law clerks whispered as the justices entered, their black robes a symbol of the court's solemn authority. It was a case that had divided lower courts, with significant implications for Fourth Amendment protections in the digital age. Justice Stephen Breyer, known for his pragmatic approach and scholarly temperament, sat slightly forward in his chair, reviewing his notes. At 83, the liberal justice had heard thousands of arguments across his distinguished career. Few expected this case would stand out among them. Representative Jasmine Crockett, appearing as special counsel for the appellant, approached the podium. The freshman Congresswoman from Texas, who had maintained her legal practice alongside her political duties, stood poised before the highest court in the land. "Ms. Crockett, you may begin," Chief Justice Roberts announced. What happened in the next 30 seconds caused Justice Breyer to set down his pen, remove his glasses, and lean forward with an expression that veteran court watchers had rarely seen, a look of genuine surprise and growing admiration. No one anticipated how this exchange would not only influence a pivotal constitutional question, but demonstrate the power of legal brilliance to transcend the partisan divisions that had increasingly infected the judicial system. Don't forget to like and subscribe to see more moments where constitutional principles rise above political differences. To understand the significance of this Supreme Court moment, we must first understand the distinctive legal minds at its center. Justice Stephen Breyer had built his reputation over decades as one of America's foremost legal thinkers. After graduating from Stanford and Harvard Law School, he had served as a law clerk to Justice Arthur Goldberg, worked as special counsel to the Senate Judiciary Committee, and taught at Harvard Law School before his appointment to the federal bench by President Carter in 1980. Appointed to the Supreme Court by President Clinton in 1994, Breyer had established himself as a thoughtful pragmatist who approached constitutional questions with an eye toward real-world consequences. His judicial philosophy emphasized making the Constitution work effectively in contemporary society while respecting its foundational principles. Justice Breyer represents the finest tradition of American jurisprudence, noted constitutional scholar Lawrence Tribe. He combines intellectual rigor with practical wisdom, always seeking to understand how legal principles apply in the lived experience of citizens. Known for his penetrating questions during oral arguments, Breyer had earned respect from colleagues across the ideological spectrum for his fair-minded approach and genuine interest in understanding all sides of complex legal issues. Jasmine Crockett brought a completely different background to the Supreme Court that day. A civil rights attorney before winning her congressional seat in 2022, Crockett had built her reputation defending constitutional rights in Texas courtrooms. Though this was her first appearance before the Supreme Court, she had argued numerous cases before the Fifth Circuit Court of Appeals. Representative Crockett approaches constitutional law with both intellectual precision and personal passion, her former law partner explained to the Texas Tribune. She sees the Constitution as a living document that must protect the rights of all Americans, especially those whose voices are often marginalized in our legal system. What made Crockett's Supreme Court appearance unusual was her dual role as both a sitting member of Congress and practicing attorney. While several members of Congress maintained active law licenses, few took on cases of such constitutional significance while serving in office. The case before the court, United States v. Merritt, centered on a critical Fourth Amendment question. When law enforcement uses artificial intelligence to analyze publicly available social media data, at what point does this surveillance require a warrant? Lower courts had issued contradictory rulings, creating the kind of circuit split that typically prompts Supreme Court review. The constitutional stakes were enormous. In an era of rapidly evolving technology, the court's ruling would establish precedent for how traditional Fourth Amendment protections against unreasonable searches apply in the digital age. Legal experts anticipated a divided court, with the three Trump appointees, Justices Gorsuch, Kavanaugh, and Barrett, potentially joining Justice Thomas in favoring law enforcement's position, while Justices Sotomayor, Kagan, and Breyer would likely emphasize privacy concerns. The votes of Chief Justice Roberts and Justice Alito were considered less predictable. What no one anticipated was how Crockett's approach would transcend these expected ideological divisions by appealing to constitutional principles that resonated across the court's philosophical spectrum. The morning of the argument, the Supreme Court press corps noted something unusual. Justice Breyer arrived carrying an additional legal pad, something veteran court watchers observed he only did for cases of special interest. Whether this reflected particular concern about the constitutional questions or awareness of Crockett's reputation remained unclear as the justices took their seats and the case was called. What judicial moments have you found most inspiring? Share your thoughts in the comments below. We'd love to hear which Supreme Court arguments or decisions you believe transcended partisan divides. Mr. Chief Justice, and may it please the court, Crockett began, her voice steady despite the gravity of the moment. The question before you today is whether the government's warrantless use of artificial intelligence to aggregate and analyze years of a citizen's public social media activity constitutes a search under the Fourth Amendment. Rather than beginning with modern precedents, Crockett took an unexpected approach that immediately captured Justice Breyer's attention. I would like to start by examining how the founders themselves would have understood the concept of papers and effects protected by the Fourth Amendment, she said. In the 18th century, citizens often gathered in public houses and taverns to discuss political matters. These were, in many ways, the social media platforms of their era. Justice Thomas leaned forward with interest. Are you suggesting, Counselor, that posting on a public platform like Twitter is analogous to speaking in a public house? Not exactly, Your Honor, Crockett responded. I'm suggesting that the founders understood the difference between isolated public statements and the comprehensive record of those statements. When government agents in the colonial era were sent to systematically monitor and record conversations in public houses, the founders considered this precisely the kind of intrusive surveillance the Fourth Amendment was designed to check. Justice Breyer removed his glasses, a sign court watchers recognized as indicating particular interest. Could you elaborate on that historical claim, counsel? I'm not familiar with that specific colonial practice. This was the moment experienced advocates dread, a direct challenge to a historical assertion from a justice known for his scholarly rigor. The court fell silent as all eyes turned to Crockett. Without hesitation, she cited three specific historical incidents from 1767 to 1771, where British authorities had dispatched agents to compile comprehensive records of colonists' public statements, naming the specific individuals involved and quoting from letters in which James Madison and Thomas Jefferson had explicitly criticized these practices. Justice Breyer's expression transformed from skepticism to evident respect as Crockett connected these historical examples directly to the digital surveillance techniques at issue in the case. Just as the founders recognized that systematic government monitoring of public discourse threatens the freedom of expression necessary to democratic society, this court should recognize that AI-driven surveillance of social media represents not merely the observation of public behavior, but the creation of comprehensive digital dossiers that reveal patterns and associations the founders would have understood as papers and effects, deserving Fourth Amendment protection. What followed was 30 minutes of intense questioning from justices across the ideological spectrum. Justice Barrett pressed Crockett on how law enforcement could effectively investigate threats that appear on social media. Justice Sotomayor asked about where to draw the line between permissible observation and unconstitutional surveillance. Justice Alito challenged her historical analogies as stretching original meaning too far. To each question, Crockett responded with a combination of constitutional principle, historical context, and practical application that transcended predictable ideological positions. When Justice Kavanaugh suggested that users voluntarily surrender privacy expectations by posting publicly, Crockett offered an analogy that visibly resonated with Justice Breyer. Your Honor, consider a citizen who walks through public streets every day for years. Each individual journey is public. But if the government used facial recognition to create a comprehensive record of every public movement over 5 years, revealing patterns of association, religious practice, and political activity, the founders would have recognized this as precisely the kind of intrusive surveillance they sought to prevent. not because each individual movement is private, but because the comprehensive record reveals intimate details of life that should remain free from government scrutiny, absent compelling justification. Justice Breyer nodded and picked up this thread. So you're arguing, essentially, that the whole is greater than the sum of its parts? That while individual public posts might not trigger Fourth Amendment concerns, the AI-enabled aggregation of thousands of such posts over years creates something qualitatively different? Precisely, Your Honor, Crockett responded. And this court recognized a similar principle in Carpenter v. United States regarding cell phone location data. The digital revolution shouldn't erode constitutional protections. It should inform how we apply founding principles to new technological realities. As her time neared conclusion, Crockett made a final point that clearly struck a chord with Justice Breyer. The Fourth Amendment's purpose wasn't merely to protect physical spaces, but to ensure that citizens could develop thoughts, associations, and identities free from unwarranted government intrusion. The founders couldn't have imagined social media, but they understood perfectly the danger of allowing the government unfettered access to the comprehensive record of a citizen's expressive life. When the red light illuminated, indicating her time had expired, Chief Justice Roberts did something unusual. Ms. Crockett, you may take an additional minute to conclude your argument. This rare extension, typically granted only when Justice's questioning has consumed most of a lawyer's allotted time, signaled the court's engagement with her constitutional reasoning. As Crockett returned to her seat, the Solicitor General approached the podium to argue the government's position. What happened next revealed how profoundly her argument had shifted the court's thinking. Justice Breyer, who typically allowed other justices to ask initial questions, immediately challenged the government's position with a question that incorporated Crockett's historical framework. Counsel, if James Madison were here today, how would you explain to him that comprehensive government monitoring of citizens' political expression doesn't implicate the very concerns that motivated the Fourth Amendment? The press corps exchanged glances, recognizing that something remarkable was happening. Justice Breyer, while never predictably partisan, had essentially adopted Crockett's constitutional framing, a clear indication that her argument had transcended ideological divides by appealing to founding principles all justices seek to uphold. As attorneys and observers filed out of the Supreme Court following oral arguments, an unexpected scene unfolded in the ornate hallway outside the courtroom. Justice Breyer, who rarely engaged with advocates after arguments, asked a clerk to invite Representative Crockett to his chambers. Such invitations were unusual, particularly coming from a justice to an advocate immediately following oral argument. Court protocol typically maintained careful separation between justices and those arguing before them. But Breyer, in his final term before retirement, had earned the stature to occasionally set aside convention when he felt circumstances warranted. 20 minutes later, Crockett was escorted into the justice's book-lined chambers. Law clerks reported that Breyer began not with pleasantries but with substance, a reflection of his respect for her legal mind. Your historical framework was compelling, the justice reportedly told her. I've studied Fourth Amendment history for decades, but your connection between colonial-era surveillance of public houses and modern AI monitoring offered a perspective I hadn't fully considered. Crockett later described this conversation as one of the most meaningful moments of her legal career. Justice Breyer didn't agree with every aspect of my argument, she recalled in a subsequent interview with the ABA Journal. But he engaged with the constitutional principles in a way that transcended ideological categories. It reminded me why I became a lawyer in the first place. What made this interaction particularly significant was that it occurred between jurists often categorized on opposite ends of the political spectrum, Breyer as a liberal appointee, Crockett as a progressive Democrat. Yet their discussion centered not on politics, but on constitutional principles both held sacred. The meeting, initially planned for 15 minutes, extended to nearly an hour as they discussed the evolving nature of privacy in the digital age. Court staff noted that Justice Breyer called in one of his clerks to take notes on several historical sources Crockett mentioned that he wanted to research further. News of this unusual meeting quickly spread through legal circles. When reporter Nina Totenberg approached Crockett as she left the court, her question captured the legal community's reaction. "Representative Crockett, there are reports Justice Breyer invited you to his chambers following your argument. Can you tell us what was discussed?" Respecting the private nature of the conversation, Crockett responded with appropriate discretion. "I can only say that Justice Breyer's commitment to understanding the Constitution's application to contemporary questions is profound. We discussed how founding principles inform modern jurisprudence in a technological age the founders couldn't have imagined." Later that evening, at a Georgetown Law School event where he had a long-standing speaking engagement, Justice Breyer made a comment that immediately generated attention throughout the legal community. "I heard a remarkable oral argument today," he told the audience of law students and faculty. "It reminded me that the most compelling constitutional advocacy doesn't seek to appeal to a justice's presumed ideology, but to the enduring principles all of us on the court strive to uphold. The best advocates understand that the Constitution speaks to us across centuries, requiring us to apply founding wisdom to modern circumstances most of the framers could never have envisioned." While Breyer didn't mention Crockett by name, maintaining appropriate judicial discretion about a pending case, everyone present understood the reference. His comments were widely reported in legal publications and shared across social media by law students and professors. What followed in the days after the argument revealed how profoundly Crockett's constitutional framing had penetrated legal discourse around the case. Law professors across the country adjusted their Fourth Amendment lectures to incorporate discussion of her historical analogies. The Harvard Law Review accelerated publication of a commentary analyzing her argument. Judicial blogs across the ideological spectrum engaged with her constitutional framework, some critically, others supportively, but all taking it seriously as a significant contribution to Fourth Amendment jurisprudence. 3 weeks after the oral argument, when Crockett appeared at a Federal Bar Association conference, the moderator asked about her experience before the Supreme Court. Her response revealed both humility and a deep respect for constitutional tradition. "Standing before the Supreme Court is a profound responsibility," she said. "You're not just representing your client, you're participating in a conversation about constitutional principles that stretches back to the founding and forward to generations not yet born. Politics has no place in that conversation. What matters is fidelity to the Constitution's enduring promise of liberty under law." A particularly meaningful reaction came from former Solicitor General Paul Clement, who had argued over 100 cases before the Supreme Court and was widely respected across ideological lines. Though Clement had often advocated positions contrary to Crockett's political views, his assessment focused on her constitutional reasoning. Representative Crockett's argument demonstrated what the best advocacy before the court should do, Clement commented during a Federalist Society panel discussion. She identified constitutional first principles that resonated with justices across jurisprudential perspectives. That's much more effective than crafting arguments designed to appeal to a presumed 5-4 split. The impact of her argument extended beyond legal circles when a law student's recording of Justice Breyer's Georgetown comments went viral, receiving over 5 million views across platforms. Comments across social media revealed public hunger for discourse that transcended partisan divisions. This is what America needs: people who care more about constitutional principles than political points. I don't agree with Crockett politically, but I respect her commitment to fundamental rights. Maybe there's hope for finding common ground on foundational values, even when we disagree on policies. Justice Breyer, with characteristic scholarly thoroughness, was reported by his clerks to have spent the weekend after the argument revisiting historical sources on Fourth Amendment origins. One clerk later revealed that the justice had instructed them to prepare a supplemental memorandum examining Crockett's historical claims in detail, an unusual step reflecting his intellectual engagement with her framework. As the court's deliberations continued behind closed doors, legal observers began speculating that the case might not produce the 5-4 ideological split many had predicted. Based on the justice's questions during oral argument and Breyer's subsequent comments, experts increasingly suggested the decision might reflect a more nuanced approach that incorporated aspects of Crockett's historical framework. 4 months after oral arguments, the Supreme Court issued its decision in United States v. Merritt. To the surprise of many court watchers, the ruling came in at 7-2, with Justice Breyer writing for the majority. Chief Justice Roberts and Justices Barrett, Sotomayor, Kagan, Gorsuch, and Kavanaugh joined his opinion. Only Justices Thomas and Alito dissented. The decision represented a measured approach to Fourth Amendment protections in the digital age. Rather than adopting either extreme position, Justice Breyer's opinion established a framework balancing privacy interests against legitimate law enforcement needs. When the government uses artificial intelligence to aggregate and analyze years of social media activity, creating comprehensive digital profiles revealing patterns of association, belief, and behavior, Breyer wrote, this constitutes a search under the Fourth Amendment requiring judicial oversight. The opinion expressly incorporated the historical framework Crockett had presented, with Breyer writing, though the founders could not have envisioned digital communication platforms, they understood perfectly the danger of allowing the government unfettered access to comprehensive records of citizens' expressive activities. The systematic monitoring of public houses and taverns that concerned colonial Americans provides an illuminating, if imperfect, historical analog to modern surveillance capabilities. Constitutional scholars immediately recognized the influence of Crockett's oral argument on the court's reasoning. Harvard law professor Noah Feldman wrote in Bloomberg, Breyer's opinion draws a direct line from founding-era concerns about government surveillance to modern AI capabilities, adopting almost wholesale the historical framework Crockett presented during oral argument. Even Justice Thomas's dissent acknowledged the persuasiveness of this approach, writing, while I disagree with the majority's conclusion, I appreciate its effort to ground Fourth Amendment jurisprudence in historical understanding rather than merely evolving societal expectations of privacy. The decision's impact extended beyond this specific case, establishing principles that would guide lower courts in addressing a wide range of digital surveillance questions. Rather than creating a rigid rule, Breyer's opinion provided a flexible framework focused on whether surveillance techniques reveal the kind of comprehensive portrait of a person's life that the founders would have understood as deserving Fourth Amendment protection. Legal experts across the ideological spectrum noted how the decision defied easy categorization as either liberal or conservative. George Washington University law professor Orrin Kerr observed, this opinion doesn't fit neatly into ideological boxes. It's both originalist in its historical grounding and pragmatic in its application to modern technology. That's why it commanded such broad support on an otherwise divided court. The Merritt decision quickly became required reading in constitutional law classes nationwide. Law schools reported that the case study was particularly valuable because it demonstrated how effective advocacy can bridge jurisprudential divides by appealing to shared constitutional values. 1 month after the decision was announced, Justice Breyer participated in a long-scheduled Constitution Center event discussing the court's term. When moderator Jeffrey Rosen asked about the Merritt case, Breyer's response offered insight into how Crockett's advocacy had influenced his thinking. Sometimes an advocate helps you see familiar constitutional terrain from a fresh perspective, Breyer explained. The best arguments don't simply apply existing precedents mechanically, but help us understand how enduring constitutional principles speak to new circumstances. That's particularly important when technology creates surveillance capabilities the founders couldn't have imagined, but whose implications for liberty they would have immediately understood. For Crockett, the court's decision represented a profound professional validation. When interviewed about the ruling on CNN, she focused not on personal vindication, but on constitutional principles. The Fourth Amendment isn't a partisan issue, she explained. Whether you're conservative or progressive, you should care deeply about preventing unwarranted government intrusion into the comprehensive record of your expressive life. That's not about politics. It's about the liberty all Americans cherish. 6 months later, Georgetown Law School hosted a symposium specifically examining the merit decision's implications for Fourth Amendment jurisprudence. The event featured distinguished panelists including former Attorney General Michael Mukasey, ACLU Legal Director David Cole, and former Solicitor General Theodore Olson, representing perspectives from across the political spectrum. The symposium's most anticipated moment came when Justice Breyer, recently retired, made a rare post-retirement appearance alongside Representative Crockett to discuss constitutional interpretation in the digital age. Their conversation revealed not merely mutual respect, but a shared commitment to constitutional principles transcending political identity. When a student asked about their different political backgrounds, Breyer's response captured the essence of constitutional jurisprudence. "The Constitution doesn't belong to conservatives or progressives," he said. "It belongs to the American people. Our job, whether as justices, legislators, or citizens, is to ensure its protections remain vital as technology and society evolve. Sometimes that means finding common ground across our differences, recognizing that certain core principles unite us even when policy preferences divide us." Crockett added, "I've always believed that constitutional advocacy shouldn't begin by asking which argument will appeal to which justice based on who appointed them. It should begin by asking what the Constitution's text, history, and principles tell us about the liberty of citizens and the limits of government power. When we approach constitutional questions that way, we often discover more common ground than we expected." The impact of their unlikely intellectual partnership extended beyond legal circles. Political scientists noted a subtle but significant shift in how some members of Congress discussed constitutional questions, with several explicitly citing the Breyer-Crockett dialogue as a model for engaging across differences on fundamental principles. Law schools reported increased student interest in courses examining constitutional interpretation, with many specifically mentioning the merit case as influencing their academic focus. Applications to Georgetown's Supreme Court Institute, which helps prepare advocates for oral arguments, reached record levels. 1 year after the decision, when Crockett announced the establishment of a constitutional advocacy clinic at Howard University Law School, Justice Breyer agreed to serve as an occasional guest lecturer. Their continuing intellectual exchange represented something increasingly rare in American public life, a relationship based not on partisan alignment, but on shared commitment to constitutional values. As Breyer explained at the clinic's opening, constitutional democracy depends on our ability to remember that beneath our policy disagreements lies a foundation of shared principles. When we forget that, we risk losing something precious: the constitutional consensus that has sustained American liberty through centuries of social and technological change. For her part, Crockett described their unlikely connection as a reminder that the Constitution creates a framework within which our differences can be negotiated without threatening the foundations of our shared democratic experiment. Perhaps the most lasting impact came not through legal doctrine, but through public understanding. As videos of the Georgetown Symposium circulated online, comments revealed a hunger for dialogue that transcended partisan divisions. "I wish more of our public discourse looked like this, respectful disagreement based on shared commitment to fundamental principles. This gives me hope that we can find common ground even in polarized times. I've never seen a better example of how the Constitution can bring together people with different political views around core American values." 2 years after the oral argument that began their intellectual connection, Justice Breyer published The Living Constitution, a book examining how founding principles apply to modern challenges. The volume included a chapter on Fourth Amendment jurisprudence that extensively discussed the merit case and acknowledged Crockett's contribution to his evolving understanding of digital privacy concerns. In the book's conclusion, Breyer wrote words that captured the essence of their unlikely connection. "Constitutional interpretation works best when we recognize that people of different jurisprudential approaches can nonetheless share a profound commitment to the document's enduring principles. Sometimes it takes someone with a perspective different from our own to help us see familiar constitutional terrain in a new light." When asked during his book tour what he hoped readers would take from this example, Breyer's response offered wisdom for an increasingly divided nation. I hope they'll remember that beneath our most heated disagreements about specific policies lies the possibility of connection through shared constitutional values. When we approach our differences with intellectual humility and genuine respect for the Constitution that binds us together as Americans, we discover that what unites us runs deeper than what divides us. This is the kind of judicial legacy America needs now more than ever. If you found this story of constitutional dialogue across differences inspiring, please like and subscribe for more content exploring how American legal traditions can unite us despite our differences. Together, we can remember that our shared constitutional heritage provides a foundation for respectful engagement even in polarized times.